said the word bullshit. Are you aware that perjury is a criminal offense in the state, punishable by up to 3 years in prison and a $10,000 fine? I'm going to motion for a mistrial, constitutionally protected.
Objection, Your Honor. It's not even accurate.
I'm asking him a simple question.
The charge, disorderly conduct, 29-17-11, this is the charge of the first division. Briefly, no person shall recklessly cause inconvenience, annoyance, alarm to another. By doing certain things, there are 4 subcategories in A1. The one that I will be prosecuting Mr. Cook on is the turbulent behavior, which has been defined by State v. Reeder and State v. Jackson as unruly conduct characterized by commotion. The facts of this case will show you that Mr. Cook approached the clerk's office in an unruly behavior, used vulgar language, loud voices, became antagonistic with staff, was asked to leave, left, then came back, rummaged through material at the security desk when the security guard was not there, knowing that that was the security desk, took material from it, and then was ultimately arrested. But those facts, which will be established beyond any reasonable doubt, establish disorderly conduct under the A1 section, and that's what the facts will show, Your Honor.
All right, thank you. Mr. Cook, do you have an opening statement?
Yes, Judge. Actually, everything that he just said will be disproven by the video surveillance. There was no commotion. I was not unruly, and my arrest was in retaliation for me exercising my First Amendment rights and my Fifth Amendment rights by the bailiffs in this courthouse. There was no criminal conduct on that date. I did not swear at anybody or raise my voice. I wasn't waving hands in the air, wasn't pounding on things. Nothing like what was described by the prosecutor will be supported by the video surveillance.
Yeah, just since we're arguing a little bit of the law, Your Honor, I do want to put on the record, since it's important, State v. Jackson, 2nd District, 1998, Ohio Appellate Lexus, 5439, Head Note 5, citing State v. Reeder, 18 Ohio State, 3D 25, 1985, the turbulent behavior provision of the disorderly conduct statute, quote unquote, does not evoke free speech concerns. Thank you.
All right, thank you. Mr. Asher, would you like to call your first witness?
Your Honor, I call Dorothy Bledsoe to the stand.
Excuse me, Judge. I'm going to have to object. I was told in the pretrial that this was only going to cover what happened on December 9th, and that I would not be able to present evidence of goings-on prior to December 9th. And all of this is history beyond December 9th. It's not direct testimony of what took place on December 9th, and that was your ruling, Judge.
Sounds good, Your Honor. I'll withdraw.
Very well.
Let's go to December 9th, Mrs. Bledsoe. Did you have an occasion to interact with Mr. Cook on December the 9th?
Yes, I did.
Tell us about that occasion.
It was a court day, so there was quite a bit of activity in the courtroom. I think it was towards the end of the docket. One of my deputy clerks was speaking with Mr. Cook at the counter, Olivia Mayo, and I believe I heard either his voice or her voice. It seemed like the conversation was a little bit loud, something that she may have needed my assistance with. Normally, if any of my clerks are dealing with someone that I think that they either need my help with as far as explaining something, or if there's a person they're having difficulty with for any reason, I usually come and see how I can assist.
And on that occasion, did you attempt to assist your deputy clerk with Mr. Cook's requests?
I did. I came to the counter and I was under the assumption that Mr. Cook had some other questions about the appeal.
Describe for the court.
Judge, she thinks she doesn't know. She can't testify to what she thinks happened on that day. She has to know what happened on that day.
Your Honor, goes to the weight of the evidence. She can testify what she thinks she knows.
I can rephrase that, Your Honor. I know that he interrupted me at one point.
Okay. As you had the opportunity to observe Mr. Cook on that day, how would you describe his demeanor?
Well, he wasn't happy with the information that I was trying to provide. He seemed to become agitated. At one point, I said to him, Mr. Cook, I'm simply trying to help you, but you just seem to be argumentative. And at that point, he became even more agitated, and he did say an expletive, but I can't remember exactly what was said. I do know that he did say a curse word.
He said a curse word, but you don't recall whether the specific word.
No, I don't recall.
But you do recall specifically, as you reflect back on that, as you sit here on the stand today under oath, that he used vulgarity towards you as the clerk.
Yes.
Did he make any other statements to you as he continued to become more and more agitated as you explained the process for the records request?
I don't remember the specifics, so I can't speak to that, but I mean, there was conversation and he was getting more upset.
Did he ask you what you thought he was thinking at any point in time during that conversation?
Well, after I had made the statement, you seem to be argumentative, he did seem to be offended by that, and he said that I didn't, how was I to know what he was thinking or to question what his motives were?
Was his, what tone of voice did he have? Was it loud? Was it quiet? Can you describe for the court, not necessarily just his words, but his vocality and his observations in discussing this issue with you?
He was louder than normal speech that you would just speak with someone. He wasn't screaming, but he was louder than normal, and he was moving around a bit and as if he was agitated.
Very good. And what happened at that point?
Mr. Major was in the clerk's office behind me, and when he initially cursed, he told him to, watch his language.
Are you aware that perjury is a criminal offense in the state, punishable by up to 3 years in prison and a $10,000 fine?
I would never perjure myself on the stand.
That's not the question I asked you, ma'am. I asked you, are you aware that perjury is a criminal offense in the state that is punishable by up to 3 years in prison and a $10,000 fine? I'm
aware that it's a criminal offense, but I did not know the penalties.
Would you take it as my word at this time that it does carry a 3-year jail penalty and a $10,000 fine?
No, I will not take it at your word.
Judge, at this point, I'm going to motion for a mistrial and a dismissal for cause, because there are at least 2 material fact witnesses to what transpired on December 9th in the courtroom, Mr. Major and Mr. Cooper. Their testimony has been irretrievably tainted by the testimony given by Ms. Bledsoe, and I don't believe that they could be rehabilitated. You issued a gag order back in March of last year to prevent witnesses from being able to speak to one another. That was to prevent them from being able to coordinate their stories. And having them in the room while the testimony is taking place does the exact opposite of what your gag order had intended to do. They witnessed the testimony from Ms. Bledsoe. Now they know what they can and can't say to corroborate what she says.
Your Honor, first of all, your gag order was applied to them speaking with each other, which they have not done. He's more than welcome to sequester the witnesses, and he didn't ask the court for that. He's playing the fumble here. Obviously, I please ask that all of those motions be denied.
Yeah, Mr. Cook, if you're asking for sequence that the witnesses be sequestered, that should have been done before Ms. Bledsoe testified. I'm not telling you how to try your own case.
Okay.
You had that opportunity. You didn't take that opportunity.
That's fine.
I'm going to overrule your motion for a mistrial. There is no indication that anything has been done improperly. So,
Well, I would like to motion that they be sequestered at this juncture.
No objection?
who are we talking about here?
Your Honor, we have Mr. Major, who's leaving the courtroom, and then we have Mr. Cooper, who will also leave the courtroom. They would be the state's witnesses here.
Very well. That motion will be granted at this time.
Your Honor, I'll turn off the speaker's system.
Very well. You may continue your cross-examination,
Okay.
Mr. Cook.
Ms. Bledsoe, are you now or have you ever been an attorney or a judge?
No,
Okay. So you have no legal training to be able to make judgments on what is and is not lawful. Is that correct?
not as an attorney or a judge, no. I mean, I've had training through the Clerks Association and seminars and such for what
Is appropriate for a
or
clerk?
training in the clerk's office, but not as a judge or an attorney, no.
Okay. Have you ever engaged in any kind of misconduct or illegal conduct while you've been in your office?
No.
Judge, I'd like to present this email at this time, being proffered to impeach the testimony of the witness on the stand. This is an email from November 12th of 2023, or 4. November 20th, 2024. And this was in the discovery packet that was given to me there for the
Yes.
purpose of...
After the fact, I knew that that's why you were there, to file a formal complaint.
Okay, so after the fact. So do you recall telling me that if I wish to file a formal complaint against you, that I could file a grievance with the Ohio State Supreme Court's Office of Discipline while we were both in the clerk's office?
I do not remember telling you that. I don't believe you would file a grievance against a clerk there. You could file a grievance against a judge. You would file a grievance with my boss, who was Judge Capper.
Right, but if I told you that you said that I could file a grievance against you with the Ohio State Supreme Court, do you have just cause right now to tell me that I...
Objection, asked and answered. Run up through each question 2 or 3 times, Your Honor, are we?
She answered your question, Mr. Cook. She said that if you wanted disciplinary action filed, it would be against her boss, Judge Capper. I believe that's been asked and answered, so let's move on.
Okay. And you testified that, if I recall correctly, that I was, that I cursed numerous times in the courtroom, in the clerk's office after Mr.
I didn't say numerous times. I remember a couple. There was once before Mr. Major asked you to cease and desist, and then you said something afterwards, and that's when he said, "All right, leave."
But you don't recall what that word is?
No, I don't.
If I was to tell you that the word that I used was the word hell, would you disagree with that?
I mean, I would neither agree or disagree because I don't remember it. It's been over a year and a half, and I don't remember the specifics.
Have you ever heard of a Supreme Court case called Cohen versus California?
No, I have not.
And again, you're not an attorney and you're not a judge and you're not a law enforcement officer either, are you?
Correct, I'm neither of those.
If I was to tell you that California versus Cohen was a decision in 1971 that said that vulgar language in a courthouse is protected free speech, would you have a reason to argue with me?
If you were directing that to my person, yes.
Explain that. I don't understand what you meant there.
Well, if you were cursing at me or you were directing that to the members of my staff, yes, I would say that you could be asked to leave the courthouse. We even have a sign in the clerk's office that says you can be asked to leave for that, or it may not specifically say that, but
Was that sign present before or when this interaction took place?
yes, it's been there for quite a while.
So you allege that I came in, I was immediately loud and disorderly,
I don't know, I'm sorry.
meaning that I was being verbose and speaking in a loud volume from the time that I entered?
I don't know because I wasn't there from the time you were entered. I was back in my office. On court days, I'm frequently traveling between my office and up front assisting at the counter. But at some point, I heard your voice and I came to the front to assist Olivia to see if she needed help or why you were there.
But you don't recall the fact that I was there to file a formal complaint against you?
Ask and answer.
I didn't do that at the time.
Okay. If I told you that that was the first thing I said to her when I showed up at the window, you have no reason to disagree with me, correct?
Correct.
I followed you in. I don't know if you would start talking by the time I got through the security door into the clerk's office or not.
Was I already engaged in a conversation with Miss Mayo when you entered the clerk's office?
It's over a year ago. I'll be honest with you, maybe. I don't know.
Okay. And so,
No, you became louder.
okay,
Your voice became louder. You stiffened up in a defensive posture. You became more. Your hands became moving more.
okay. And so you said that I said the word bullshit. Is it possible that I said the word hell or bullshit?
No, it's bullshit.
Okay. If I was to advise you that she testified to that fact, that stipulated that fact, that she said that I was here, she thought I was here just to be difficult or disagreeable. Can you say that that's a lie?
The objections calls for speculation. He said he didn't know what she said.
He can testify to what he knows.
Okay,
Or what he saw, what he heard, what he smelled,
Okay.
tasted.
constitutionally protected?
Objection, Your Honor. This is not even accurate.
I'm just asking him a simple question.
Your Honor, we're here on an A1 charge. I've read the law. It's Ohio State black letter law. This charge has absolutely nothing to do with protected speech. That's black letter from our Supreme Court. The A1 violation of tumultuous behavior for unruly conduct causing commotion has absolutely nothing to do with freedom of speech.
And
Go ahead, Mr. Cook.
And I disagree with the characterization, and I'm trying to get to the fact that I was told to leave the building because I said a bad word. And that's what I'm trying to draw out now.
I think the record and testimony reflects he was asked to leave for a series of things.
I'm going to sustain the objection, Mr. Cook. The freedom of speech, as Mr. Ashworth has stated, is not going to be a part of this charge. It's not a defense to the charge of disorderly conduct in this instance. But go ahead.
Are you aware of whether or not there's video surveillance in this case?
There was.
Was it furnished to the court or to the defense?
Yes.
Was it furnished to the prosecution?
Well, hold on. What prosecution? I'm not the prosecutor's office. I know this is hard. I'm certainly not being antagonistic to Mr. Cook. When I have a conflict with the prosecutor's office, I am the investigator, the records custodian, the paralegal, the attorney, soup to nuts, as they say. So when you say this, the prosecutor's office have it, that's a conflicted office that I'm completely siloed from. I don't even call them to ask them for stuff, even for a template. So I want to make sure that that's clear, that when he says, was it provided to the prosecutor's office, it might have been, that's just like saying, was it provided to some other attorney? It wasn't, I'm not that person.
What you're saying is you did not.
The first time I even knew this case existed, there was no video that I could get. Now, Mr. Mulford, his prior attorney, has it, but as you can imagine, Your Honor, he doesn't want to give me anything because there's some other thing going on now with them. So I don't have a video. He can play his video. I know it exists, but to ask, I just want the court to be sure, and he's more than welcome to introduce into evidence that the other prosecutor's office had it, but I don't have it.
Judge, I also have evidence that he was provided it.
I still have it.
Okay, well, there is a video, you're going to be permitted to play it, so I don't know what the relevance of the question you're asking Mr. Major here regarding it has to do with anything.
Well, Judge, my contention is that I was not disorderly pursuant to the statute, and that I was ejected from the building because I said a dirty word. And video surveillance will bear that out.
Okay.
And that's why I was asking Mr. Major if he is aware that it is perfectly lawful to say a curse word in a courthouse.
It's not an accurate representation of the
That's
law.
not an accurate representation of the law.
Video in the clerk's office window was like, what, 30 minutes long? He stood there for 30 minutes, is that accurate? And you were what, 3 feet away from him?
If that.
If that. There's no video, or excuse me, there's no audio that accompanies any of these videos, is that accurate?
Our system does not record audio.
And is there anything that you saw on the stuff that you watched that you believe you should change any of the prior testimony that you gave under your direct examination earlier?
I do not.
Without lawful command to leave, that there cannot be a criminal trespass.
I advise you to leave.
That's not my question. I asked you, and I'm going to repeat it. Are you aware that without a lawful command to leave, there cannot be a criminal trespass?
I ordered you to leave.
It's not the question. Judge, I'm going to ask you to instruct him to answer.
I don't understand the question, Your Honor.
And his testimony stands as it is. I'm not sure what you're asking here.
I'm trying to get to the concept of lawful orders versus unlawful orders, Judge.
I think it's your call, Your Honor.
Look, I'm the finder of fact here this afternoon. I've heard testimony. I can hear your testimony if you wish to do that. He's already testified as to what he said, so let's just move it along.
Well, let me ask you this. Did you ever hear me on that day raise my voice?
No.
So while you were in the clerk's office, at the security desk, while you were in the courtroom, you never heard me raise my voice?
Not in the clerk's office, not to my recollection, no, I do not.
So,
Mr. Ashworth.
Yes, Your Honor. Briefly, I think those videos pretty much prove what we needed to prove. He came in for 30 minutes. He argued with the clerk's office. It's undisputed at this point that he used some type of vulgarity. He says hell, they say bullshit, whatever. You don't do that to a clerk, especially when they're trying to help you out. He did that. He was approached by security. It looked like they gave him every benefit of the doubt for 33 minutes. We watched the video. As he sat there, he became aggravated. Mr. Major was a few feet away from him with 27 years of law enforcement experience. He testified pretty unequivocally that Mr. Cook was agitated. He was causing a commotion. And then, on top of all of that, he leaves the building, being requested to do so, and then returns. He is technically trespassing and then rummages through material that he knows for certain is not something that he should be rummaging through. So what I would ask the court to do holistically is to look at all of these facts and then look at the State versus Jackson case. This is clear. Tumultuous behavior. If I've proven beyond a reasonable doubt that there was unruly conduct that was characterized by a commotion, if the facts establish that, then he is guilty of a violation of 291711A1. So that's tumultuous behavior. It's the same thing. Vulgarity in and of itself, I agree, that standing alone is not necessarily disorderly conduct, but when you couple that with technical trespass, even though I didn't charge him with that because we see more restraint than he certainly gives anybody credit for. They gave him an opportunity to rummage through that desk. They gave him an opportunity to cuss at the clerk, and now he's trying to use that to suggest he didn't do anything wrong. Well, clearly, he caused a commotion, and he was unruly, he was guilty of disorderly conduct, and the evidence shows that. Thank you, Your Honor.
All right, thank you, Mr. Cook.
Judge, if that's disorderly, then any normal conversation between two or more people is disorderly. Number one, the only thing that they can point to is the fact that I shuffled my feet or swayed back and forth. I happen to have a bad back. That 9.5 years in the Army, I've got a bad back. I move periodically.
Move to strike. That evidence is not in play, Your Honor.
People with medical conditions sway back and forth all the time. There is zero evidence of disorderly conduct. That was a cool, calm, collected conversation where the use of one foul word cannot be disorderly, and the video surveillance shows that there was no conduct that was in any way, shape, or form creating a commotion to attract attention or do anything of that nature. I was quite calm, and I would say that if, and this is why I wish to bring Mr. Morford forward to present to testify, if I was being loud and obnoxious and causing a commotion, the people that were in the clerk's office would have taken notice of that. The other people who worked in the clerk's office who were present, I pointed to the one lady who was walking around with a hamburger, would have taken notice. Nobody took notice to it. Mr. Cooper testified himself that he never heard me get loud. He never heard me raise my voice. And there's just far too much evidence to the contrary that I committed any kind of criminal act.
Any rebuttal?
No, Your Honor.
Very well. Well, this thing's gone on for quite a while, frankly. And, 2917-11 reads, and I think this is the section that we may be under. No person shall recklessly cause inconvenience, annoyance, or alarm to another by doing any of the following: making unreasonable noise or an offensively coarse utterance, gesture, or display of communicating unwarranted or grossly abusive language to any person. You know, it appears both Ms. Bledsoe and Ms. Major have testified that this was offensive to them. They asked you to leave. Now, I don't see why, I understand why they may have, I think they overcharged you with theft, frankly. It was probably an unauthorized use of property. You didn't ask anybody if you could write before. So, but do you have anything to state regarding punishment in this matter?
I'm indigent. I'm a disabled combat vet, and I live on my VA disability.
All right. In that case, I'm going to make it a $50 fine and court cost. Now, there was, Mr. Ashworth, you had asked this court for sanctions. You filed a motion for sanctions. And I believe that was filed on November 17th of 2025.
Yes, Your Honor.
Do you wish to address that?
I do. I will maintain that. What we saw in this was egregious misuse of the court's time and resources. There was significant motion practice that was completely unnecessary after several warnings, and the fact that I'm even here was the result of efforts made to basically file complaints against everyone that's involved in this. The commissioners have now been required to pay a bunch of money that they frankly shouldn't have paid. There's going to be an appeal. I'll have to ask the court to extend my special prosecutor appointment to this case so that I can address the appeal, and we are going to spend more money on something that's clear. It's disorderly conduct. I should have maintained the theft and trespass charges. Of course, he has absolute no ability to reflect upon his own actions, and that's a problem.
Mr. Cook, anything that you'd like to say regarding that?
No.
Okay. Mr. Ashworth, I'm not going to rule on that. I'm going to defer, if this is going to be appealed, I'm going to defer to the Court of Appeals. They'll have the entire record here, Mr. Cook, and they can determine whether or not the conduct you've engaged in would allow for some type of sanctions to be imposed. I think you did file a bunch of things that didn't need to be filed. I'll be honest with you. I think you looked at a lot of things. I suspect, speaking of AI, I suspect you used AI in order to, well, maybe you didn't, I don't know. And I'm not going to say you did. But what I am going to say is, you're not a lawyer, you know that, I know that, and a lot of the things that you filed were absolutely irrelevant to the matter here at hand. I wish you the best, but I think you need to change your attitude when you're conducting business with people. This is an old man's advice, that I see attitudes that are good, I see attitudes that are bad, and it's not, you don't get anything done if you have a bad attitude. You know, it's you get more flies with honey, or you could get it with male bovine excrement. I don't know, but I won't say the word that was allegedly said by you. So I wish you the best, but that's going to be the order of this court, and we're adjourned.